Hi, everyone. Welcome to the webinar today. So excited to have you and very excited to have Brewer Offord and Pedersen LLP, Ashlee and Adam with us again. This is actually going to be our third webinar with you guys. So congrats. And thank you everyone who's followed along on this series on California leases. I just want to mention a couple of things. As usual, the presentation is available for you to download if you want a copy of it, and there's an outline as well. We'll be sending you the recording as well as the outline and presentation tomorrow. So even if you miss something, we'll send it again. And also, we'll have a Q&A at the end. And so far, the last two have gone over a little bit on the hour, but we'll see how it goes. And we may stay a little longer for that. The other thing too, just want to quickly introduce Adam and Ashlee real quick if you haven't heard from them already. Adam is a senior partner and real estate attorney with Brewer Offord Pedersen LLP, and he has over 8 years of experience as a relentless advocate for real estate brokers, landlords, property managers, agents, and he's also a broker, licensed broker himself. So he definitely has a lot of experience with real estate transactions and title disputes, close of escrow issues, you name it. Ashlee is a junior partner and real estate attorney as well at Brewer Offord Pedersen LLP. And she helps real estate investors and homeowners, landlords, agents, and brokers with issues like partition actions, unlawful detainers, duty of care, disclosures, and other real estate legal issues. So thank you guys both for being on here again. Very excited for this topic, and take it away whenever you're ready.
Thank you.
Thank you. And thank you for joining us again on this, our fourth, I believe, webinar for the AAOA. So glad to be back and appreciate you guys having us back. Again, my name is Adam. I am a real estate attorney with Brewer Offord Pedersen. I've been doing this for some number of years now and have a lot of experience representing property managers specifically and other licensees of the BRE in matters involving landlord-tenant issues, among other things. So looking forward to talking a little bit about lease termination today. Ashlee's going to lead us off for our first section. But before we get into the nuts and bolts, we have our standard disclaimer. Now, for those of you who joined us for the last few webinars, this is where I would make a joke about we're not responsible for what we say, but I feel like probably that's getting old for most of you, so I'll just jump right into it and just make my more real and cautionary note that the information we give you today is really just general principles of law, and if you're looking to have these laws applied specifically to the facts of your case, you should probably seek out an attorney's help in so doing. Either ourselves, we'd be certainly grateful to take that on for you, or someone that you trust, because the general law is certainly can change wildly depending upon the specific facts of any given case.
Right. So first we want to talk about, you want to get a tenant out of your property. You first have to look at what are your options. One of those first things that I like to look at when I have a client come in is their lease. And one of the more common termination causes that landlords have at their disposal is expiration of a fixed term tenancy. I'm not sure about Adam, but I've seen most leases nowadays been for 1 year, 12 months, however you want to word it in the lease, but it's becoming more and more common, one for security for the tenant and also for the landlord. You don't have to get a new tenant every couple months. Also, there's some cities and counties in California that are actually requiring you to offer a 1 year lease. So it's not only becoming a preference, but sometimes a requirement.
And I think locally, I know there's others who aren't from the Bay Area, which is where we find our home office, but locally I believe it's Mountain View is one of the recent ones that has enacted such a statute.
Yeah, in Palo Alto as well, where we're located, you have to offer a 1 year lease. You don't necessarily have to enter into one.
Mm-hmm.
It's up to the tenant, but that is an important requirement. But it's also a great way to terminate a lease. And one of the major benefits of it is the lease terminates automatically. We have a lot of clients come in that ask, do I need to serve a 60-day notice or 30-day notice? The answer is You don't have to technically serve any notice unless the lease provides for that, but under the law, a fixed term tenancy terminates automatically. There's no notice requirement. But that's not exactly cut and dry. A lot of times what happens is the notice period is not required, the lease terminates automatically, and then the tenant continues to pay rent and the landlord accepts. One of our biggest keys of advice in this situation is do not accept rent past the fixed term period if you want the lease to terminate automatically, because when you do, say if the lease terminates July 31, if you accept rent on August 1, now you have a periodic tenancy, which we'll talk about later, and either 30 or 60-day notice is required. And so if you do want to terminate at the end of a fixed term, make sure you do not accept rent past the term. But it's one of the most common, easiest ways to terminate a lease, and you don't need notice. Although, we'll get into it later, there are some things you need to do before the termination of the lease. You don't have to serve notice, but there's pre-move out inspections and things you need to notify the tenant of, to where before you terminate the lease, they need to have certain rights accounted for, but we'll get into that. Next, Adam, you want to take it away?
Sure. The next thing to look at is how you terminate a periodic tenancy. That dovetails nicely with what Ashlee was just talking about, which is a fixed term tenancy. The only thing I would add to what Ashlee was just saying or reinforce is, and I get clients sort of suspect about this all the time, and when they come in at the end of the fixed term lease saying, okay, my tenant hasn't been paying the rent or doesn't seem like he's moving out and the lease ends in a week, I'm a little nervous. I always say, barring anything in the lease that would change this general principle of law, you can file the eviction immediately. Yeah. Because no notice is required, and that's typically what I advise the landlord to do if that's the appropriate thing to do if the tenant doesn't leave as planned. So it's really an important advantage, and accepting the rent can give rise to a periodic tenancy, which is usually disadvantageous to the landlord. So what if you have a periodic tenancy, or what if one has arisen and now you need to terminate it?
Right.
There's really no difference in the way that periodic tenancy is going to get terminated, whether it was one that was part of a written month-to-month agreement from the inception of the lease, or whether it arose as the matter of the expiry of a fixed term lease and then creation of a periodic tenancy, which is actually quite a common way that a periodic tenancy arises. I mean, a lot of times people don't, and this is certainly something that we would say is not a best practice, but people don't create a new written lease agreement for that subsequent term. So year one goes by, everything's great, tenant's nice, we're getting along well. And so I just keep accepting rent as I normally do after the end of the expiry of the lease. Periodic tenancy does arise. It's going to be treated just like a month-to-month tenancy from the inception. And so you've got to take certain steps to terminate that periodic tenancy. It's really primarily all about the notice. And there's two terms that are relevant in California. One, if the tenancy has been less than a year, it's a 30-day notice. If it's more than a year, it's a 60-day notice. You can serve it at any time. You don't have to wait until the end of the beginning of the month. We get this question a lot about, what if they've paid rent for, September? Do I have to wait till October 1st to serve the notice? No, you can serve it, in the middle of the month, and then the lease would terminate accordingly in the middle of the following month. Now, of course, you can only collect rent for that time period. You can't collect a full month's rent on the subsequent month because the tenancy is going to terminate halfway through, so you've got a prorate for that month. But rent questions aside, it's a 30 or 60-day notice to terminate that periodic tenancy.
And just to add, if we are moving a little too fast, periodic tenancy essentially means a month-to-month tenancy or by means of payment of rent. So if a tenant, this is super uncommon, but if a tenant pays rent annually, the periodic tenancy term is for 1 year. So don't get too bogged down into it's a 30-day period in the lease. It's whenever the tenant pays rent. So just make sure if you have certain tenants that pay for the year or 2 years at a time, that periodic tenancy is actually a year term. So I just wanted to clarify that.
Yeah, and that's a good clarification. The period of a periodic tenancy, that's why we use the word as lawyers, even though month to month is probably the most common way for lay people to describe it, because the period isn't necessarily a month.
Right.
Though, again, that's pretty rare.
Okay, so we have, I call them no-fault terminations, the expiration of the fixed-term lease, and then the periodic lease. We want to move into the tenant essentially doing something wrong and you want to get them out. And so the first one for that is a common one. It's not related to rent. And in this situation, you typically use a 3-day notice to quit. And there's some important tips about this. Number one, you want to explicitly say what the tenant is doing wrong. If they're breaching paragraph 14 or 17 or whatever it is in the lease, make sure you put that. I even copy the language from the lease into the notice so the tenant can't say that they don't understand what they're doing wrong. Also adding specifics, if there's a time period they're doing it, or certain people involved, make sure you're very specific, because the last thing you want is to file an eviction and the tenant says, well, I didn't receive notice, it was unclear, I didn't know what I had to do to cure it. You don't want that. So number one, be specific. Also document the violation if you can. I talk to clients about this and it's very frustrating. One of the most common ones that's difficult is smoking in the unit, whether that be cigarette or cannabis. How do I prove that? I want to serve a 3-day notice. You do that. But how do you prove they're doing it or they're not doing it? It's very difficult, and that's sort of the catch-22 that a landlord is in. But if you have any documentation, you have emails from neighboring tenants, if you get a declaration, anything you can, you want some kind of evidence when you do serve this type of notice, because you want to show before when the tenant was doing it, when they were doing it during the notice period, and potentially even after, because if you file an eviction, the judge will want to know, how do you know they did this? How do you know they didn't fix it? And so we get into the situation where we're evidence gathering it, and we suggest doing that from the get-go. And I don't know if you have anything to add to that in your experience.
Yeah, I mean, just to only to reinforce what you've already said, which is make sure that you can document. I mean, some of these are easy, right? You know, like I have a list that I just jotted down here, some of the most common ones that we see. Smoking, you touched on, is one of them. Pets is another big one.
Yeah.
And then one that we've been talking more about lately is the cannabis issue, both the consumption of it, which is, you know, smoking from a legal standpoint or a lease standpoint, and also the production of it. So growing cannabis plants is something that the landlord can preclude, and is something that tenants may not understand because they may feel like the state law has given them the right to do that, which it has under certain circumstances, but not where the landlord has just said no. So those are some of the ones to look out for. Pets tend to be an easier one to do because it's harder for the tenant to hide the pet or get rid of the pet within that 3-day time period. But the smoking ones can be difficult. Similar to smoking noise complaints, you know, we've done a lot of, and some of them pretty interesting lawsuits that have to deal with noises being made in other apartments that are affecting the quiet enjoyment of the neighboring units, and proving that that noise problem has not stopped can be difficult.
It's very difficult.
It can be difficult. And I've seen these in court play out. Literally, the tenant will come in and before the housing court judge and, you know, explain, oh, I stopped doing that when I got the 3-day notice. I haven't done it since. And typically, if there's a mix of evidence, the judge may quite often push it down the road or issue some sort of interim order, causing the parties to come back to court later on to address the issue. So, you know, it can be difficult, and usually the tenant is given some deference in showing that they've addressed the issue. So evidence is key.
Agreed. Next, a little bit more straightforward reason is failure to pay rent. This is they either paid the full amount or they didn't. Abide by the lease to make sure that the rent is actually late. The leases typically say 5 days, but the landlord can require it in a day or 2 days, whatever it is. But make sure you don't serve notice until the rent is actually late. So if the rent is due on the 3rd of every month, don't serve notice until the 4th. Don't cut their payment period off. Also, during that 3-day period, you have to allow the tenant to pay rent. You can't say that it has to be a cashier's check or a check or electronic payment. If they want to pay in cash or whatever is most convenient for them, the court will require you to allow them to do so. Don't get too bogged down into abiding by the lease in regards to payment method. You have to allow them to do it within a reasonable procedure. Also, after the 3-day notice period ends and you do want to file an eviction, make sure you don't accept rent. And the most recent questions I've gotten about that is I use Zelle or I use direct deposit, something like that. Well, that's actually okay. So you may get that rent payment on the 6th or 7th or 8th electronic transfer. All you want to do is get on the phone or go to your bank and say, hey, I want to return that money, or you write a check to the tenant, you give it to the tenant. You just want to make sure that you return it as soon as possible, because the courts have said, we understand that there's this new element of technology, but you need to return it as quickly as you can. If you go and use that money for something, or you wait 3 weeks, whatever it is, it's going to be deemed accepted. But as long as you return it within a reasonable amount of time, the courts have actually said that you're okay. So that's generally how a failure to pay rent works. It's fairly simple. It's more of just timing, and then making sure you don't accept after the notice period. And this includes utilities, anything for, PG&E, anything like that, beyond rent, any contribution to the property you do not want to accept after that 3-day notice period. And then last, you just need to make sure that you abide by rent control. We've talked about this before. It's it's becoming more and more common, but a lot of times you may have a reason under the California Civil Code or whatever the case may be, but the local ordinance contradicts that. For example, in San Jose, there's just cause eviction, and in that city, you have 12 reasons why you can evict a tenant. If you don't fit within those reasons, right, you can't do it. So I would say the first place to check is your local county or city rules, and then go expand from there, because ultimately the tenant will be protected from the inside out. Right. So just make sure that you look up local rent control in addition to the reasons we gave, to make sure you're not violating the tenant's rights.
Yeah, and that's a very important point. I mean, under the law, by default, if I can refer to it in that way, under California law generally, I guess I should say, you can serve, if there's a periodic tenancy, a 30 or 60-day notice as appropriate at any time.
Yeah.
You don't need to give any reason. A lot of times people struggle with that. Oh, what do I tell the tenant about why and all that stuff? You don't have to explain.
Yeah.
You're entitled to do that, but not so in a rent-controlled jurisdiction, not so at all. There is usually 8, 10, 12 very specific enumerated reasons, some of them very complicated, about what needs to happen before you can evict a tenant. So, do not run afoul of those rent control laws, especially in areas like Oakland or San Francisco. It can be very expensive if you make a procedural misstep. And that includes even if you have factually basis to bring an eviction under just cause.
Yeah.
If you don't follow the appropriate procedures, you can run afoul of the statute. And I've dealt with that on a number of occasions where, the property manager or the owner has done some research and said, oh, I'm an owner, I'm going to move in, so therefore I'm entitled to evict, and then they move forward with the notices, and they've made procedural errors in that because there's more requirements to that specific cause to evict. And then what happens is not only do they fail to evict the tenant, but they set themselves up for a tenant harassment case based upon the use of these facially invalid notices to try to evict.
Yeah.
And it really just compounds the problem. And I've seen those become pretty complicated in court.
Very, very common.
Expensive to resolve, most importantly.
So now we've gone over causes. The next step, at least in our situation, or even yours, is to draft the notice. And so we just want to give an overview of more so war stories, I think, and pitfalls that you can encounter in drafting them. And when you file an eviction based on those notices, if you do mess up, they more than likely send you right back to the beginning. So you're going to end up back in the notice drafting. So we want to make sure you do it right the first time. First is a 3-day notice to cure or quit. We talked about this before, but some things I wanted to know. Number one, it's either non-payment of rent, and then you have non-compliance, and I think this is where we come in pretty handily and helpfully, is not all reasons in the 3-day notice to quit are curable, and the client needs to be aware of that. There's some things in the lease and in the law where you can serve a 3-day notice and put that in when you're drafting it, and the tenant actually cannot cure that. Usually it's illegal activity, or if they're subleasing. There's certain things that are basically they cut off their tenancy, and you just need to serve notice, and the tenant can't go and stop that activity to cure it. So in that case, it'd be a 3-day notice to basically leave. So make sure you know, number one, what the non-compliance is, and then dig a little bit deeper to determine if it's curable or not, because you don't want to give the tenant an opportunity to fix something that they potentially don't have the right to do. Also, as I mentioned, I put the lease clause in there, and I also put a code section if it is based on that for non-payment of rent. There's a code section for that you can put on the notice, but just make sure they understand and know how to correct. Next, 30-day notice. Do you want to talk about this one, Adam?
Sure. I mean, as we were discussing before, the 30-day notice is one of the most common forms of notice used to terminate a periodic tenancy. Again, by default, under general California law, rent control aside, you don't need any specific reason or motivation to serve one.
Right.
It could just be that you prefer to get a new tenant in there. That's just nothing wrong with that if that's what you want to do, so long as it's not discriminatory or harassing, which I'm assuming for purposes of today's conversation it's not. You can go ahead and do that. One major misstep we see people making is Civil Code section 1946 has language in it that is required to be in the 30 or 60-day notice. If it is not in there, then that notice is not valid. And so what, you may ask, if the notice is not valid? Well, it doesn't terminate the tenancy, and you can't use it as a basis to start an eviction action, or what's also known as an unlawful detainer action, to get the tenant out. So you either are going to lose that case if you file based on that notice and the tenant challenges it, and then you're gonna have to start from the beginning, or you're gonna have to reserve the notice. It's not as painful as when we're dealing with 3-day notices. If you make an error and the tenant still hasn't paid rent, you could potentially serve another 3-day notice.
Just 3 days,
and
right?
It's only another 3 days. But if you have a 30-day notice requirement, or if we have a requirement for a 60-day notice, you can see how this can really start to add up and become a burden. So you want to make sure that you're including the specific requirements of each form of notice when you serve it.
Right. And just a practice point for people out there, if you want to draft your own notices for 30 or 60 day, there's literally quotes in the code section that you can copy and paste, and I suggest you do that and put it at the bottom of your notice. It has exactly what you need to include in there, and it's all revolving around abandoned personal property. And we'll get into the procedure for that, which is, it's kind of a pain, but you want to put the language in the notice, number one, so the tenant knows, but also it's required, as Adam said, you could start back in the beginning.
Right.
Same thing for 60-day notices, same requirements. This is typically the most common one, just because, as we said, fixed term tenancies for 1 year are becoming the norm, and so anything after that would require 60-day notice. So make sure you have the right amount of days, and then also those 1946 requirements are vital. Next, so you've served notice, you determine why you served notice, and now, you know, it's not, you don't just wait till the notice period is over. You have some things as a landlord that you need to do to make sure the move out goes smoothly, and you give the tenant the rights that they're entitled to under the law. And one of those first things is a pre-move out inspection. And I actually have a blurb that I send to clients, or I send to tenants after we serve notice, and it's all revolving around the Civil Code section in the slide, 1950.5, subsection F. It's very specific. And it doesn't really give a specific time period when to give this notice, but it just says reasonable. So I usually do it a month before move out. I would say 3 weeks is reasonable. You want to tell the tenant, number one, that you want to schedule a pre-move out inspection, or you want to give them the opportunity to do this. Under the law, under this code section, they have that right. You have to offer them the move out inspection. And number two, you want to explain what it's for. So if they have a $5,000 security deposit, sometimes it's way more than that. You want to do an inspection, number one, to check the property out before they move. But number two, you want to point things out that you will deduct from the deposit so the tenant can have the opportunity to fix those things. If you don't offer this inspection and just start deducting things after they move out, the tenant technically has an argument to get their deposit back because they never had the opportunity to fix those things. If it's painting the wall, fixing a hole in the carpet, whatever it is, if you have a handy tenant that wants to do it themselves before they move out, they have that right. And so make sure that you're offering your tenants a couple weeks before this move out inspection, because you don't want to wait until 2-3 days before you can do the inspection and they have no time to actually fix anything.
Right.
So it's actually not reasonable notice. And so this is a big one. I seldomly see landlords even be aware of this or do it. It's on my checklist of things to do before move out, and it's not just good practice, it's required. So.
Yeah, and a couple of notes on that. I mean, the theory behind this statute and the pre-move out inspection, as well as the other parts of how the security deposit is handled, try to balance the interest of the landlord and the tenant in that security. So the tenant gives the landlord a security deposit at the outset to protect the landlord against damage to the property. But then the landlord assumes an obligation to sort of care for that money, not spend it, keep it separate, keep it accounted for. So it's the tenant's money, it's not your money at that point in time. And then at the end of the tenancy, the law wants to give the tenant, as Ashlee was saying, that one last chance to fix the property up. So if you don't give that opportunity, you lose your entitlement to that deposit. And now why would the law do that? Well, because the law offers you the opportunity after the tenant vacates to, during that 21-day period, go in there, find things that may have been broken or that need to be repaired that are chargeable to the tenant, and then it allows you to basically summarily charge the tenant without any judicial interference, without any need to go to court or anything like that. You can simply charge the tenant for those items, and then it's on the tenant to challenge those deductions if they think that you've done them wrongly. So it's kind of it's advantageous for the landlord, but it's subject to that very important condition of allowing this pre-move out inspection. And I agree with Ashlee, like, I think this gets missed all the time.
Yeah, and even when you do offer that inspection and you do the inspection, you want to provide them with an itemized statement, and similar to the one you do after they move out, which a lot of you may know you have to serve within 21 days and all of that, which we'll talk about. But you want to provide them in the notice as well and in the statement that this is what I can deduct for, this is what I will deduct for, so they're aware of that. So even something that's not pointed out from the time of the inspection up until move out, they know if they mess something up or if they ruin something, if they don't pay that last month's rent, you will deduct from the deposit. And I put it in the slide there, it's 1950.5. Just really read that whole section. It's fairly wordy, but it's important. But subsection B and then 1 through 4 are the reasons why you can deduct from the deposit. I have a lot of questions about that, and I direct people to read that section just for their own information, but make sure you tell the tenant about that as well.
Right.
Okay.
So stipulated move out date. I
like this one.
That's where you have come to an agreement with the tenant.
Right.
And this can take on many forms. One, maybe you've got a 1 or 2 year lease and the tenant would like to leave a little bit early. And you say, okay, well, that's fine. I got some notice. I can get a new tenant in there. It doesn't make sense to fight over that 1 or 2 months or whatever they're looking for. So you stipulate to an earlier move out date. Or perhaps the fixed term tenancy has converted to month to month. The tenant comes to you and this says they want to move out. So you agree again to a move out date that may or may not be consistent with the strict sort of 30 or 60 day notice type time period. And the final one would be, if the tenant has maybe been not paying rent, and rather than go through an eviction proceeding, you agree to a move out date to avoid an eviction process. So totally fine. I am a huge advocate of parties trying to resolve things among themselves. As much as I love it when they come to me to help out, I understand the expense and the time involved. And if you can get it done on your own, you're certainly better off, so long as you can do it right and so long as you know what to expect.
Yep.
And I say that with regard to the stipulated move-out date for a couple very important reasons. Number one, that stipulated move-out date is, without getting overly complicated about it, probably not enforceable in court, right? Because there's no eviction proceeding pending. So it's not like you can convert that agreed upon move-out date immediately into an order for the sheriff to come out and get the tenant out. So that's a problem. So a lot of times, for example, in the cases of non-payment of rent, I will advocate actually against stipulating to a move-out date prior to the filing of the eviction. Now, that doesn't mean I don't advocate that after we've got the eviction on file, because then we can do a different kind of stipulation that is what we call court enforceable or subject to a judgment of some kind. So you want to be careful if the stipulation is arising out of a problematic relationship, you want to be careful. Another thing to think about is if you are going to stipulate to a move-out date, you know, we can use things like cash for keys potentially in certain jurisdictions to facilitate that, wherein the tenant gets some money when they deliver the keys or possession at the end to try to give some teeth to that stipulation, again, because we know that there could be problems enforcing it in court. You know, a written agreement doesn't hurt. You know, it's nice to put it in writing. It's not certainly legally required, I wouldn't say, but it could be on the level of if the lease requires only written modifications, then that might be a legal requirement, but typically it's not a requirement.
I like to do it, the written agreement, because a lot of times in the agreement, I put the parties agree that the lease terminates on this date, and then you get into a situation where if they don't leave by that date, arguably you can file an eviction right away. It doesn't negate the eviction, but you don't have to serve 30 or 60-day notice, so that's the benefit I see.
You've in effect created what is a short-term fixed duration lease, and so upon expiration, as we talked about before, you can go ahead and file. And that's actually a great tactic to use because it does eliminate that what can be lengthy notice requirement. And then also, you know, if there's evidence of an agreement and motivations for that agreement, it could help to cut off any defenses to eviction later. So if the tenant comes to you, obviously, and says, hey, I want to move into a different place, can we agree upon a move-out date? And then you do that, and then for whatever reason that falls apart and you end up in court, you've got a record now of the tenant's motivation and thinking over time. And if you put it in writing, as Ashlee suggests, you've got a written agreement that starts to coalesce that. So you avoid some argument about, you know, what could happen later on. One caveat I will throw out about stipulated move-out dates, they can be difficult to manage in rent-controlled jurisdictions. The specifics of that, I think, are a little bit outside of today's conversation, but just so you know, if you're in a rent-controlled jurisdiction, you're going to want to be very careful about stipulating to a move-out date that's different than a notice date or the expiry date of the lease, because depending on the motivation for it, it can start to look like tenant harassment, or that you're trying to force the tenant out and turn their unit over to get higher rent. And so you want to account for that. And also, I would say most rent-controlled jurisdictions have some kind of relocation expense that's in there with that. And if you are essentially offering less money, or if there's less value changing hands than the move-out statutes provide for, you could end up running afoul of those statutes, which only compounds those sort of tenant harassment arguments and stuff that exist. So you want to be careful about how you structure those in a rent-controlled jurisdiction.
And, you know, I think it's a common understanding we have as lawyers under the law, but a lot of lay people actually aren't informed about this, but you can't contract out of certain rights. And that's what it comes down to. You can't contract out of certain buyout prices, notice requirements, things like that. So make sure that you're not contracting the tenant out of a statutory right, because a lot of times the statute will trump that. So you just have to be careful. Next, post move out. And, you know, a lot of people think that the tenant leaves and you got the property back, that the race is over and you can take a deep breath. Well, that's actually not true. Unfortunately, actually a lot of work can happen after move out, which we'll talk about But one of the first things that I want to do, I recently had a case on this, and it ended up being very pricey for the landlord and property manager jointly. Make sure the tenant has actually vacated, and I know this seems obvious, but it's not. A lot of times tenants say, yeah, I'll be out by a certain date, and say that date was tomorrow, Friday. And they've moved out most of their things, and it looks like they're out of the property, everything's all fine and well, and you go there on Saturday and you change the locks. This actually happened in a case that I was involved in, and the landlord property manager settled the case for several tens of thousands of dollars because it was considered a self-help eviction by the landlord and a lockout. Tenant came back on that Sunday, couldn't get in the property, and he never relinquished possession. And so number one, make sure that the tenant either confirms in writing or you have some kind of proof that they are officially moved out. That's why I put written confirmation. Also make sure they hand over the keys either to your property manager or to the landlord themselves. Make sure there's some affirmative act by the tenant that they have vacated. If they just look like they are gone, be very careful. There's actually a civil code I put in there from that case I learned about, 789.3. They have strict penalties, and one of the biggest ones that I learned about was even if your lease provides for no attorney's fees for either side or a cap for $1,000, 789 opens the door back up, and you could be liable for tenants' attorney's fees on top of the damage to locking them out. So this is the big one. I think it's overlooked, or you get an anxious landlord that's trying to move back in or whatever the case may be. Make sure they moved out.
Right, and to dovetail on that, it raises, I think, what are a lot of real textbook issues. That one case that Ashlee was talking about lease termination and abandonment, and the various pitfalls, including the issue of, was there abandonment of the property, was possession delivered, and also stipulated move-out dates. All those facts were in play in that case. And that goes back to what we were just talking about, where you got to be careful, right? Because again, a stipulated move-out date, if the tenant says, oh, I think I can be out by October 15th, that's not the same as surrendering possession under the lease or relinquishing or abandoning, or even agreement, right, for that matter. And so you've got to be very careful just sort of acting upon those types of conversations and then locking the tenant out. I mean, that's really risky conduct, and it doesn't matter if you think that you're in the right or otherwise. You've got to adhere to these provisions. And so one other thing that we didn't touch on before as far as termination goes, if you have a tenant who has abandoned the property, California law, it's section 1951.3, lets you, if there's been no rent paid for 14 days, you can serve what they call a notice of abandonment. There's certain ways that you need to do that. You need to read the statute or talk to a lawyer if you want to figure that part of it out, but there's requirements about the kind of notice you give. And then 14 days if personally delivered, or 15 days after that, after the delivery of that notice, then you can deem the property abandoned and safely, change the locks, retake possession, and things like that. So just a few simple, cautionary steps at the outset could have completely avoided the case, and many cases for that matter. And so it's just really important to know what you're doing before you do it, have a plan in place, and then act on that versus just sort of reacting to what you see on the ground.
And even if you have a written agreement or even a concrete date from the tenant, do not rely on that at all costs. It's action-based. The court will not care if the tenant said, yeah, I'll be out December 10th or whatever the date may be. They're going to look at what the tenant actually did. It's never going to stand, oh, well, the tenant said that they were going to be out by the 10th, so I went on the 11th and changed the locks. That's in no way acceptable. It's very risky. You want written confirmation afterwards, and number two, what the tenant actually does. If they give you the keys or if they leave the keys in the unit, whatever it is, just be very careful. And if you're a property manager, make sure you set those expectations for your client ahead of time. Don't tell the client, look, the tenant agreed to this date, they're going to be out, everything's going great. sort of give them the warning or the disclaimer like we give you, saying, look, this is the agreed upon date, but I can't do anything without, number one, a court order, confirmation of their move out in writing from the tenant, or handing over the keys. There has to be some kind of affirmative act or order. That way the landlord's not going to come back to you and say, what the heck's going on? You told me this date. You've already told them what worst case scenario looks like. I think as a property manager,
Right.
you have to be a risk analyst too and provide that information to your clients, because the last thing you want is them being surprised by having to file an eviction or having to wait 2 weeks, whatever the case may be. I think that's just a practice point. That's not anything legal. It's just saving you from grief from the property owner. And I think you can attest to that as well.
Yeah, I mean, as the property manager, obviously, I think most of you who are managers know you've got an obligation to your owner to do your job competently. And if you miss something like this, it raises a couple problems. Number one, because you're the owner's agent on an agency theory, the owner is liable potentially for your acts.
Yep.
Right? And so that means, for example, if there's attorney's fees in the lease between the owner and the tenant, and the owner feels like you didn't competently do your job and now they find themselves in hot water, well, it's no surprise who they're going to come looking to for a recompense. And so quite often you'll find yourself in the middle. So it's not really enough to sort of blame the owner or blame the tenant. You've got to take responsibility for it yourself from the outset and make sure that it's done appropriately,
right?
Lest you find yourself in the crosshairs of a owner-tenant dispute.
All right. So the next thing, and a lot of times my clients are disappointed in this law, just because, like I said, you think you're at the finish line and potentially you're not, is abandoned property. So one of the first things you want to do after you've confirmed the tenant has vacated, after you change the locks or whatever the case may be, you want to immediately take an inventory of any personal property left behind. And this could be anything. This could be pillows to a piano to clothes. I've seen everything. Sometimes they don't really care and they just leave it behind and say, oh, the landlord will take care of it. And that's fine. But you have a responsibility as an owner, property manager, to handle that property appropriately, regardless of the intention. So once you've taken an inventory, the next thing you want to do is evaluate that property. So in cases, under the civil code, the dollar value right now, if the property is worth $700 or less, actually less than $700, you give notice, and the way you give notice is different. They have a certain amount of times, usually 14 to 21 days, to recoup that property. If they don't, you can sell it, you can throw it away, you can do whatever you want with it. But they get a certain time period to get that property back. If it's worth $700 or more, it's a little bit more involved. The statute requires the landlord to either have a public auction or sell the property or do something with it along those lines. That's not always the case. If you have specific questions about this, you can ask me. But number one, you want to inventory it, and number two, you have to value it and make sure you serve notice. And a lot of times the common sense question is, okay, where do I serve this notice? Because the tenant's moved out, they've left property behind. This goes back to pre-move out. One of the things you want to ask your tenant about is, what is their forwarding address? This is super important. At move out or prior to move out, you want to get this, because this is where this notice goes, and that's why you don't just reach the finish line when they vacate. You need information for after. So number one, you either serve the notice on the forwarding address given, and if they don't provide one, they don't know or they don't answer, you actually serve the notice on the property address, which makes no sense. But under 1981, you serve it on the subject property. So you can do that, but I actually recommend other methods in addition to that. So serve it on the property address, but also email it, fax it, send it where you think they work, where you think they live. Anything that could bolster your argument that they got notice is appropriate. It's not required, but again, there's a lot of things we talk about that aren't required, but just better your chances of abiding by the law. So this is a big one. 1981 is the code section. If you want to look at it, there's several subsequent code sections that you can review. I can help you draft a notice if you need that, but make sure they didn't leave property behind either intentionally or unintentionally. Next, you want to talk about the security deposit, Adam?
Sure. Yeah, and I'll just, for a minute, with respect to the abandoned property issue, I mean, it's really can be boiled down to 3 steps. I think number 1, make sure that the property is actually abandoned, right?
Yeah.
This goes back to what we were talking about, termination tenancy. Make sure the tenancy is terminated in one of the many ways that we've already talked about. Number 2, as Ashlee has just described in detail, go through that inventory and valuation process. Number 3, sell or dispose, right? And in between 2 and 3, store. You've got to take care of it. You know, you've got to put it somewhere where it's going to be safe. If that means a storage unit, it means a storage unit. And frankly, if that means you have to incur those costs, that's just what you have to do. And that period's going to be 15 or 18 days, depending on how you gave the tenant the notice of that abandoned property. So just make sure that you're adhering to that, because that's what the law requires, and keeps you out of hot water later on. So, you know, abandonment, number 1, inventory and value, number 3, store and dispose.
Right.
Civil Code section 1950.5 is the one we turn to next for the security deposit. We actually dealt with this quite a bit previously in today's webinar, so I'll kind of just go over it again briefly. Before we were talking about the pre-move out inspection requirements. They're coming from the same portion of the civil code.
Mm-hmm.
So let's assume now you've done that, you've done your job, you've done the pre-move out inspection, you've identified those things at the time that were existing chargeable to the tenant, and the tenant has now at this point vacated and either fixed or not fixed some of those items. So you go back into the property again, you do your inspection. For those items that the tenant has fixed, obviously there's no charge to be made.
Right.
For items the tenant has not fixed, or for new items of damage, no surprise, new items of damage can readily occur when one is moving out, so it's not unusual that there would be damage different from that which you saw in the inspection,
Right.
whether because furniture was blocking it or whatever. So I say that to make sure that people are aware of, just because you didn't identify it in the pre-move out inspection doesn't mean that you're precluded from bringing it forward after move out.
It's a
right?
big misconception, right?
Now, to be clear, if it was existing and readily apparent during that pre-move out inspection, I think there could be some argument on that point. If you didn't say to the tenant, hey, I'm going to charge you for this hole in the wall that we can all see or whatever it is, maybe there's some argument that because you didn't flag it, you can't charge for it now. But that's certainly very much the exception, not the rule. I don't think I've ever actually seen it happen. So you have 21 days to do that. That time period can be extended if there's more extensive repairs necessary, but again, not as common. Typically it's 21 days. And no matter what, even if it is extended, there's still stuff that you have to do within those 21 days to be in compliance with the law. So you're going to have to take action within those 21 days, regardless of whether or not you intend to keep deposit monies for longer or not, or if there's still repairs ongoing or not. So typically during that 21 days, you identify the things to repair, you repair them, you take those receipts, whatever invoices you have for all that work, you compile them, you make an itemized statement of those repairs, do a little accounting against the deposit, and you send that to the tenant. It's that simple.
Right.
You've got to do it. And this is where actually I see a lot of people messing this up, is in the case where there's unpaid rent, right? I'm sure it's not news to any of you that quite often the tenants just assume the deposit's going to get used for the last month of rent, even though at least the CAR form lease and probably most other form leases say that's not the case. It happens all the time. And so you still need to do that statement, and you still need to show, hey, I'm charging you for the rent. Now, if the deposit exceeds the rent, which is possible, you need to return the balance, or if there's charges in addition to rent, you need to make sure that those are in your itemized statement as well. But non-payment of rent needs to be part of that itemized statement. It's not exempt from that, even though it's not a repair. I think that's probably why it gets missed. People assume, oh, it's not a repair, it's for rent, so I don't need to do that. Not true. You still need to do the same procedure. And then the same rules apply with respect to forwarding address and planning for that, 1950.5 itemized statement. You want to get that address, get contact information, try to get it to them in alternate ways if you can. If you've got an email and you've communicated that way before, do it. I mean, Ashley makes a good point. It's not required. There's no requirement that you email it to the tenant. But I can tell you that, I've been in court and having these conversations about whether or not the tenant was notified, and I've seen judges ask landlords, well, did you email it to the tenant? Were there any other ways you communicated? How else did you try to give them notice of this?
Yeah.
And if your answer is no, I can't say that it's going to be decisive, but I can tell you judges don't tend to ask questions they don't want answers to. So it can only, I think, benefit you on some level if you can show to the court that you've sort of bent over backwards to get this information to them.
And you want to talk about just briefly on what the penalty is if you don't do this?
Sure, yeah, and if you don't do this, this is where it really gets scary.
Yeah.
The penalty can be twice the deposit. So number one, you lose your right to the deposit, okay? So you don't get to keep the deposit, and even if there's damages, right? Even if there's damages, you don't get to keep the deposit.
Sure.
Now, that doesn't mean you can't sue for those damages, but that's a separate question. So you lose your right to the deposit, and you can be charged up to twice the deposit for a bad faith failure to comply with the code section.
So then you're looking at a triple.
It could be what we call treble damages. Sometimes you hear that. It's not really treble damages, and this is maybe me just being a little bit picky, but it's double damages because the deposit is not your money. When you take it from the tenant, you're holding that money on the tenant's behalf. So if you have to refund the deposit, you're not giving the tenant anything. You're simply restoring that money to the tenant. And then if you lose your right to the deposit and you have to give it back, that, in my opinion, is not damages. What is damages is the double damages you pay because you fail to comply. But you'll hear a lot of people refer to it as treble damages. Now you know the more specific answer to the question, and you can give them that relatively boring answer that I've given you, and you'll be the hit of the party for clearing that up for everybody. So anyway, just make sure you comply. It doesn't apply to all failures to follow the code. To be clear, it's for bad faith, and what that means is the subject of varying court opinions. So, for those of you who are managers, because you do this so often, your risk of a bad faith finding certainly goes up. For those who maybe manage.
$15,000.
Right.
So you're looking at a sizable sum.
Yeah.
For sure.
Yeah. And we've seen deposits even higher than that on really high-end properties, in the tens of thousands of dollars, because the rent could be in the tens of thousands of dollars.
Okay, so gone through most of termination as detailed as we can. We just want to give some recommended actions. This goes in line with not necessarily being legally required, but things that we recommend. So first, changing the locks. I would almost always do this. Tenants can make copies of keys. You can have a safety issue to the new tenants. It doesn't cost very much, but it gives you peace of mind, because if you don't do this, the penalty of it is much higher than the cost of changing them. If you have a tenant come back as disgruntled, or there's a crime that happens and you could have changed the locks, you may or may not be liable. I've seen cases even look at the area that you're in. So if you're in an area that is crime ridden, even more reason, but even if it's not, that's a big one. Number two, make sure you inspect the property before moving in a new tenant. Make sure that all your habitability issues are resolved. If there are any, water heater, make sure the windows are working, doors are locking. It's so common to just get a new tenant in the next day or the next week and not actually assess the property. It's much easier to fix issues without a tenant. So take advantage of that time period where you don't have anyone in there. So whether you have to do some repairs or fix flooring, make sure that you line up your contractors for that time period, because that's a big convenience you could take advantage of. And number three, review and renew your lease agreement. So if you had a tenant that moved in 2016, the CAR form lease has updated as of 2018. So make sure you're revamping your leases. Don't just use the same one because you're missing out on disclosure forms, new law, all these things that occur almost yearly. So make sure you review and renew your lease. And I'm sure there's more you can add.
Yeah, no, I mean, reviewing and renewing the lease is critical. I've seen a lot of people use the CAR, California Association of Realtors form. I know that a lot of other places might use the AR form set or some other more commercial type form set. I'm sure that all the varying organizations have their own form set, but they get updated. That's one of the advantages of using those form sets is they get updated. And just a small example, the CAR form that Ashley's talking about was relatively recently updated, and there was a change made to the attorney's fees provision. Before, it was just a simple prevailing party attorney's fees provision.
Open-ended, yeah.
Right, anybody who wins, they get their attorney's fees paid. And that was huge leverage to a lot of tenants' attorneys, especially in rent-controlled jurisdictions, where the likelihood of the landlord prevailing is really low, right? In San Francisco, for example, you've got the law stacked against you. You've got juries who are going to come in the door, probably not very happy with landlords. The housing crisis is real in those areas. And so you've got all these disadvantages. And on top of it, you've got a potential open-ended blank check for the tenant's attorney to litigate the case. Not where you want to be. So the CAR form was changed to cap attorney's fees at $1,000. And so one of the first things I do when a client walks in and they've got a tenant issue is I look to see what age of the form they've got and whether or not they are going to be subject to that $1,000 limitation or not. And conversely, you need to know about those changes, because if you don't want to limit your lease in that way, then you're going to need to modify that form going forward. So anyway, very important to keep up on those changes.
Okay, so now we want to open up the forum to you to ask questions you may have. If you haven't already sent them in, go ahead and type those in, but we'll go ahead and get started and we'll answer whatever we can.
All right, great. Thank you guys. So we did get quite a few while you guys were talking, so I'll just get started here real quick. So the first one was from Christine. With failure to pay rent, if the lease states that rent is due on the 1st and a late penalty is assessed 3 days following the due date, can you issue a 3-day notice as of the 2nd, or must you wait until the end of the late period?
I'll answer that one, and it's fairly simple and great question, actually. Thank you for asking, because you can get into a lot of trouble and restart the whole eviction if you do that. Number one, you can serve it on the 2nd, and the reason for that is 3-day notices, you actually cannot charge late fees. You can only give notice for rent, and so that late fee period only comes into play in the eviction action. So what happens is you can serve notice on the 2nd, make sure you only do that for rent, very important, you cannot include fees, and then you go through the eviction, you get a judgment, all of that, and that's where the late fee will come into play. You can get a money judgment, that's what we call it, after the eviction, and that's when you can account for that late fee if they are indeed late. But I would serve it on the 2nd, and it's just super vital that you only do rent. I think that answers your question. I don't know if you have anything to add. I think that's...
Yeah, I would just, I agree with what Ashley's saying completely. And I think that what the question might also be referring to is, problems that you may have heard about before with the difference between, a grace period, what we might call a grace period, or extended time to pay versus a late fee. Mm-hmm. And with late fees, Ashley's absolutely correct. And the answer to the question is you don't need to wait for the late fee to be assessed to serve the 3-day notice. The other question is more nebulous, and it's a question of practice. It's not usually written into the agreement that the tenant's going to have a grace period. Usually it's written in there pretty clearly that rent is due on the 1st, and that's it. And so you want to be careful that you don't develop a pattern and practice of allowing a tenant certain time to pay. I'm just going to invent an example. Let's say you've got a tenant and they just happen to get paid once a month, but it's on the 4th or the 5th. And so after they've been with you for a couple of months, they come to you and say, hey, do you mind if I pay my rent on the 6th? I don't get paid till the 5th, and it's stressing me out. And you let that happen. An argument arises that you can't serve that notice until after that grace period, if we want to call it that, has elapsed. Now, it's not, certainly there's counter arguments to that. Was that reduced to writing? Did the lease require it to be reduced to writing? What's the impact of that? So it's not necessarily set on arrival, but if that's the relationship, that goes, I think, a little bit beyond a late fee type situation, and that might require some further evaluation.
Right.
Okay, perfect. And then a question about the security deposit 21-day period. Is that calendar days, and does it include holidays and weekends?
That's actually a great and relevant question. As far as I know, 1950.5 is still calendar days. And why do I say still? As of September 1st, any notices and also the summons for a eviction complaint now only count business days. It's a huge law.
Mm-hmm.
I don't recall the Senate bill off the top of my head. I can certainly send you information on that. But now only court days, or what we call business days, will count. So say if you serve a 3-day notice on a Friday, the time period starts the next day. Now it will be Monday, Tuesday, Wednesday instead of Saturday, Sunday, Monday. And so while it's not on topic to your question, yes, 21 calendar days, but as a new law, which we could do a whole webinar on, it's business days for notices, and that's for 60, 30, 3, and then also the complaint service.
Okay, and then for a tenant who wants to move out, do they also have to give a 60-day advance notice if they want to leave?
Typically it's 30, and the lease will dictate this. It doesn't run, it's not mutual, and so 60-day notice is required for a tenant, but conversely, I would say it's typically 30 days, and I think Adam can attest to that as well.
Most of the leases provide for a 30-day notice for the tenant.
Yeah, it's typically not mutual. I mean, the lease can provide for that. If you want 60-day notice as the landlord, certainly put it in there. But if it doesn't mention it, or if the lease says it's typically 30 days.
I believe the CAR form provides for 30 days. And then just sort of as a practice pointer, right, what I would comment on that is there's two situations really when a tenant's going to be terminating a lease. They're either going to be terminating it during a fixed term tenancy, which is one situation. They've agreed to rent the apartment until, the end of the year, and now it's halfway through the year and they want out early. Or it's a month-to-month tenancy, which is essentially terminable at will by either side, subject to the notice requirements. And so there's that. And so my typical advice would be, hey, as a landlord, if you've got a tenant who wants out, work it out, right? I don't know that it's good practice to say, oh, tenant, you're supposed to give me exactly 30 days. I'm going to charge you for the full 30 days or whatever it is. Try to figure out a way to work it out, because landlord-tenant law, just as a general matter, does not tend to favor the landlord. And depending on where you are in California, the jurisdictions don't tend to favor the landlord. Right. So a lot of these sort of ticky-tack issues are ones best left, I think, unlitigated and just simply resolved amongst the parties.
I agree.
Okay, and sort of related from Teresa, if a tenant gives less than 2 weeks notice, not the required or agreed to 30-day notice, and they have not paid rent, can you issue a 3-day notice to pay or quit for the entire month's rent and a 3-day notice to quit for move out and uncurable for breaking notice requirements?
I mean, I don't know that I have enough facts to completely evaluate both of those questions. I can see if I can kind of parse out the question here. If the tenant hasn't paid rent for 2 weeks and the rent was due on the 1st and now it's the 14th, yes, quite clearly you can serve a 3-day
for the whole
notice for the whole month. And that's true. Same is true on the 2nd or the 3rd, right? If rent is due on the 1st and it's not paid, you can serve a 3-day notice, and that's for the whole month. You don't need to prorate that 3-day notice when you serve it. So there's that. As to the other notice requirement, it's not entirely clear to me from the question what notice requirement in the lease we would be violating and why a 3-day notice would be required. So I'm going to have to unfortunately punt on that one, pending greater factual detail. But Yeah, I don't see how that fits in with a 3-day notice.
Go ahead.
Okay. And for security deposit, 2 questions related. One is Kevin. He's saying that the tenant had a dog and it chewed the wood exterior of the garage. It's a structural damage, and he wants to hire a professional to fix it, but it's going to be very expensive. Is this a type of repair that you can charge the tenant for?
Yes, absolutely. Number one, because it's beyond normal wear and tear, that's in the code section, and that's not something that's regular. So number one, if you allowed pets and there's some tracks in the carpet or minimal damage, I would say that's pretty regular and ordinary. But chewing wood is certainly not ordinary. So yes, you can deduct that from the deposit. And hopefully you did an additional pet deposit or something like that. There's actually an addendum with the car form for pets, which actually provides for this kind of protection. But I would say solely based on it not being ordinary wear and tear, go for it. Make sure that you're reasonable in your repairs though. If you can't get some luxury contractor that does some improvement beyond what the property already was, I would say deduct to get back to where you were, to restore the property. If you get into some kind of situation where you're using that deposit to put in marble tile or a certain kind of special wood, you got to be careful. But yeah, I would say go for it.
Yeah, and certainly if the lease didn't allow for pets, definitely the basis to charge for that would be pretty solid. And then from a damages standpoint, yeah, you can charge for repairs, not upgrades. So it's got to be a repair to the property, and you still have to follow the procedures set forth in 1950.5.
Right.
So you still have to adhere to that.
Okay, just 2 more questions here. One is related to the late fees. There's still a little bit of confusion. What do you do if the tenant refuses to pay the late fee? Has California removed late fees? I think they got a little confused with that part of it.
I've seen some legislature on this. The law actually does not favor late fees all around. Judges don't as well. Typically for 3-day notices, you're only going to be able to notice for rent. And so if they paid their full rent and it's late, I don't want to say you're out of luck. That's a little bit cut and dry, but you are not going to be able to evict based on a 3-day notice. Essentially what the 3-day notice is a failure to pay rent, and a late fee is not considered rent. And I think you can agree with that. It's more of a damages cost. I would say, I mean, maybe you can get that somewhere in the deposit, but even then that's very difficult. I don't think it's in one of those in the code section, but.
Right, and late fees are still recoverable as part of the eviction, so you can include the late fee in the eviction when you file after the notice period expires if the rent is not paid.
Yeah.
So, it's not as though it's not on the table. And then also to kind of make an analogous point, all these unlawful detainer procedures and the procedures for the deposit are procedures that are sort of very specific to those moments in time. That doesn't mean that you may not, as the landlord, have a right to bring a lawsuit of some kind at a different point in time or at the same time to recover some of these monetary damages.
Yeah, breach of contract.
Right, breach of contract, or if there's damages that go beyond the security, for example, that could potentially be recoverable. So there's other options available. This is not necessarily limited to the procedures set forth in the unlawful detainer statutes and in the security deposit statute.
Okay, and last question to finish this up, although there are a few others I may send to you all after the webinar, but this one is, what do you do post move out about personal mail delivered to the former tenant? What are the landlord's responsibilities after they move out with the mail?
I'm not personally aware of a specific code section, but I would say best practice in this situation is go to your post office, contact the tenant, number one, to get a forwarding address. And they have a specific procedure where you can give that to the post office to make sure any mail that's addressed to that person is diverted. Also notify the tenant keep it in a safe place, collect it. Do not open it. That's a felony. I think we all know that. But if you
I was
want,
gonna say, look for the checks and keep those. No, I'm just kidding.
so
Don't do
collect,
that.
you can collect it and tell them, hey, you have mail here you can pick up. But I would say right away, get to the post office and do their diversion procedure. I've done that before, and just also be very careful and preserve their mail. Don't throw something out that you think is valuable, or don't open something that you think is interesting. I would say use common sense, but you either can go the post office route or care for it and let them know, or both. I think that's really the best advice that I have.
Yeah, or if it's something like a package or something like that that you can't easily deal with, there's always the return to sender option that you can employ.
Yeah.
Okay, perfect. Well, that wraps it up. Thank you guys again for coming on. This is super informative, and definitely going to be sending you some more questions. And for those of you still on the call, thanks for sticking around. I will send you the recording tomorrow along with the presentation and the outline, so you can review that later. And if you have any questions, just reply to that email, and I will connect you to Adam and Ashlee here so they can help out as well.
Thank you.
It was a
Thanks,
pleasure.
guys.
Thank you so much.
Take care, guys.